Welcome back to part 2 of our special investigative report titled Landlord Denies Telling Tenant to Grow Weed, where we continue to delve much deeper into this unfolding legal drama between tenant Sarah Jenkins and her landlord, Mr. David Miller, examining the latest developments in this highly contentious dispute. Last week in part 1, we first brought you the shocking initial allegations directly from tenant Sarah Jenkins herself, who publicly claimed that her landlord, Mr. David Miller, had explicitly instructed and even encouraged her to cultivate and grow cannabis plants right there on his rental property premises. But today, in this exclusive Part 2 update, Mr. Miller has come forward with a vehement and strong denial of these serious accusations, stating publicly that he was utterly shocked and appalled by Sarah Jenkins' bold claims against him. In an official statement carefully released through his experienced legal team, Mr. David Miller asserted confidently, "I have never at any point, and I would absolutely never, instruct any tenant of mine to engage in such clearly illegal activities on my property under any circumstances." Meanwhile, our dedicated news team continues its thorough investigation into this increasingly complex and intriguing case, meticulously examining all the available evidence as presented by both the tenant Sarah Jenkins and landlord David Miller in this ongoing dispute. Sarah Jenkins' initial and detailed claims prominently included various text messages exchanged between her and the landlord, as well as several recorded phone conversations that she firmly alleges provide strong support for her personal version of the troubling events that transpired. On the other hand, Mr. Miller's skilled legal team has pushed back hard, arguing persuasively that these same communications have been deliberately taken out of their original context and do not in any way constitute a clear or direct instruction to grow illegal substances like cannabis. Furthermore, they have suggested openly that the messages in question could easily be misinterpreted by anyone reading them casually, or worse, potentially even fabricated entirely, which naturally raises serious and critical questions about the true authenticity and reliability of this digital evidence. To gain further clarity on this matter, we recently spoke at length with renowned legal expert Dr. Evelyn Reed, who brings years of specialized experience in both landlord-tenant law and criminal defense cases just like this one. Dr. Evelyn Reed carefully explained to us that proving such a specific and damning instruction from a landlord can be incredibly challenging in court without exceptionally clear, unambiguous, and irrefutable evidence to back it up completely. She further noted with emphasis, in cases like this, the heavy burden of proof always lies squarely on the tenant to demonstrate beyond doubt the landlord's direct involvement, clear intent, and explicit directive for the alleged illegal activity. Overall, this escalating case powerfully highlights the many complexities and potential pitfalls involved in verbal agreements, ambiguous digital communications, and their interpretations during heated legal disputes in rental situations. In direct response to Mr. Miller's firm public denial, Sarah Jenkins has now openly expressed her deep disappointment, mounting frustration and unwavering resolve in the face of what she sees as evasion. Speaking exclusively to our on-the-ground reporter, Jenkins stated resolutely, "I'm really not at all surprised that he's denying everything now, but his denial doesn't in any way change or erase the absolute truth of exactly what happened between us on that property." Despite the pushback, Sarah Jenkins continues to maintain her original firm stance throughout, insisting confidently that she possesses more than sufficient concrete evidence to fully support and validate all of her serious claims moving forward. As a result, this heated legal battle between the two parties is widely expected to intensify dramatically in the coming weeks as both sides gear up thoroughly for potential formal court proceedings ahead. The immediate next critical steps in this process will undoubtedly involve extensive further evidence discovery by both legal teams, along with possible attempts at out-of-court mediation before it escalates to a full-blown trial. Ultimately, this high-profile case stands as a stark and timely reminder to all landlords and tenants alike about the vital importance of always establishing clear, detailed, and fully written agreements in every single rental contract to avoid such misunderstandings. Our news team pledges to continue following this fast-developing and captivating story very closely, delivering all the latest updates and breaking developments to you as they continue to emerge in real time. Thank you sincerely for joining us today for this in-depth Part 2 special report on the landlord denies telling tenant to grow weed saga. Please stay tuned with us for even more comprehensive coverage in the days ahead.